A Tennessee couple is under arrest, accused of treating their children essentially worse than animals. We're talking about a 6-year-old child allegedly locked in a dog kennel in the middle of the living room, not once, but repeatedly as punishment. And when police found him, he was covered in bruises with fresh welts on his little body. But that was just the beginning. Inside the home, 7 young children, all under the age of 7 years old, living in what police are calling deplorable and unlivable conditions. No running water, feces smeared on the walls, and trash covering the floors. One child was brave enough to escape and run for help, and what happened next? It led officers straight into a nightmare. I'm Kennedi Walker, and this is Law and Crime. Tennessee parents Jason and Amber Hoffer are now behind bars after police say their children were living in filth, bruised, and locked in cages like animals. According to documents obtained by Law and Crime, it all started around 7:30 Tuesday morning when 2 small children were spotted alone in the middle of the road. One of the children had severe bruising on his leg, and they both told Knox County Sheriff's deputies they were hungry and had not eaten. Authorities tracked them to a nearby home where they say the conditions were deplorable. Inside was allegedly trash piled on the floor, feces smeared on the walls and in the bathroom sink, reportedly no running water, and 7 children ages 1 month to 7 years old, all living inside. Those children were immediately taken to East Tennessee Children's Hospital, and what those children allegedly told investigators is horrifying. A 6-year-old, the same one who cops found walking on the road, claimed they were locked in a metal cage in the middle of the living room as punishment, padlocked in. And if he misbehaved, Jason would allegedly beat him with a metal pole through the bars. Deputies say the child had severe welts on his hip, bruises on his bottom and shoulders, injuries that appeared consistent with abuse. The child told investigators they escaped the cage that morning and grabbed another child to run with them, and that's how they ended up on the road. When officers went back to the home, they say they found the metal dog kennel, but noted there were no pets living inside or outside the home. Jason Hoffer now faces charges of child endangerment and aggravated child abuse. Amber Hoffer is charged with 2 counts of child endangerment. And here to break down this story with me is criminal defense attorney and former prosecutor Josh Corman. Josh, thank you so much for coming on today.
Thank you for having me.
So let's just jump right in. The alleged details, we're talking about a kennel, a metal pole, feces smeared walls, all beyond disturbing, right? When prosecutors see something like this, how does it shape their approach from day one?
Well, these are certainly disturbing when you hear these, and sadly, we hear these kind of things more often than I think people realize. Where DCS or somebody is doing an investigation, do a home visit, and then they find people, especially kids, living in conditions that we, one, that are atrocious, and 2, that we just can't imagine that someone in our communities are living like that. So when they do happen, I think it's a shock to everybody.
How critical is the timing here? Prosecutors have to prove not just what happened, but how long it went on, right?
Well, to some extent, one of the charges is felony child abuse. I think that is going to be a charge from, like you said, using a pole, the bruises. The allegations are that the child is being hit by someone, and so that does rise to an aggravated child abuse. The other things, which may be even more alarming, when you hear about the conditions or about a child being in a cage or something like that. Those are actually going to be a little bit more difficult under the statute because there's not a specific injury that the child has, and so sometimes you have to be a little bit more creative under the statute of how you're going to charge a situation like that.
Yeah, and in this case, the 6-year-old had the courage to, according to the complaint, escape and run for help. But how often do these type of cases, just go unreported because kids are too afraid to speak up or just don't know what's normal?
Right. I think, like I said, I think they're more common than people realize. Even in cities, we find cases where a child is chained up in a house, or a kid is being locked in a closet or locked in a room. And if you don't have another sibling that's old enough to go to school and tell somebody at school, or if someone at the school doesn't see bruises or something on the child, then you're right. A lot of times those cases do go unnoticed for a long period of time, or maybe forever before anyone ever finds out about it.
If this does go to trial, can we expect the 6-year-old to testify, or is he too young?
No, I believe a 6-year-old probably would testify. And what I would imagine is going on now, if it hasn't already happened, is those kids. I think there was one that was 1 month old. It just said there were 7 kids, a month old up to the ages of 7. I would assume all of the kids that can speak probably have gone to a child advocacy center to meet with a forensic interviewer, to be interviewed about anything that may have happened to them or anything that they may have seen. And those recordings are admissible in court under Tennessee law. And so the child may have to testify, but then whatever it was that they said on the forensic interview is also recorded, and those are admissible in court as well.
Well, that just has to be challenging. I mean, we hear about adults saying how scary testifying is and just how just nerve-wracking just the overall experience. So I'm just trying to imagine a child as young as 6 years old. I mean, clearly trials take time. If this does go to trial, they may be a little bit older, but testifying against anyone is scary, let alone your parents.
100%. And that's the reason that those statutes exist. In different states, you may have a statute where it allows a child to testify in a different room, by closed circuit television where they're not in a courtroom. In Tennessee, that's not allowed. But in Tennessee, they do have these forensic interviews for anyone under the age of 18. And so, like I said, the interview takes place in a child advocacy center, which normally it looks kind of like a house. The rooms are small, and it's just a one-on-one interview with someone who is trained to interview kids, and those interviews are recorded. And that way, at a trial, you can play that interview. So if a child does get up on the witness stand and they freeze, or they're too scared to answer questions, or someone has gotten to influence them and they just say they don't remember things, the law allows that video interview to be played. And obviously, at that point in time, everyone would have already known. As far as the prosecutor and the defense attorney knows, they already know what's going to be on that video. And so then that is able to come into evidence for the jury to see. So that is kind of the legal attempt to try to protect kids from the trauma of what it is like to have to testify in court.
Right, because we're talking about some major allegations here. I mean, allegedly locking a child in a dog kennel. It's hard to even say that out loud. I mean, does that rise to the level of torture under the law?
It certainly could. So under the Tennessee statute for child abuse, child endangerment, which is what the 2 people were charged with, I think there were multiple counts of aggravated child abuse and aggravated child endangerment. One of the clauses is that the conditions were especially heinous, atrocious, or cruel. And those are somewhat vague terms. They're not defined under the law, and that does kind of give the prosecutor some of that leeway that we talk about in kind of crazy situations like this where, maybe the statute's not specifically going to say that it would be child abuse to chain someone up or child abuse to lock someone in a dog kennel, because that's just not something that would have occurred to us, but it's broad enough to take those kind of factors into consideration.
And we can assume that the kennel itself is now in evidence, right? So if this does go to trial, the jury, they will probably be able to see it, maybe, in person, not even just pictures.
I would assume that it probably was seized, and there probably is going to be a bunch of photographs that were taken of all the conditions of the house, wherever the dog kennel was, or the living room, or all of that. So whether they actually bring the dog kennel into the courtroom or not, I don't know. I think you're right. I think that would probably have a huge impact on a jury to see that. But just the pictures alone, at a minimum, I think that would be used as evidence in trial.
And what I found was interesting was that when I was just reading the documents, authorities noted that they found this kennel in the living room, but they didn't find any pets outside or inside. What type of explanation could the defense possibly have for that? Because clearly a kennel is for a pet, and they're saying they don't have one.
Right. I would assume that there's going to be some explanation for that, or that they did have a dog until recently before, and that's why they had bought this dog kennel, before, or, the dog was at another relative's house when this incident happened, or something like that, of why they had the dog kennel. Hopefully for all of us, it doesn't come into evidence, or it's not going to be evidence that they bought a dog kennel just for the purpose of confining a child in it. Although I guess no matter how you look at it, it's going to be a horrible fact for a jury to hear.
The child claims he was beaten with a pole through the bars. Could that detail elevate charges or add enhancements?
Well, right now he's charged as high as it gets. So under Tennessee law, this is a Class A felony. So child abuse, aggravated child abuse for a child under the age of 8 years old is a Class A felony. So that's the highest charge you can have in Tennessee. So that would carry between 15 and 60 years in prison at 100%. So, like I said, besides a murder, this is as bad as it gets.
Wow, 50 to 60 years. And they would have to serve all of that time.
Correct.
Wow. Yeah, that is a lot. And we know that both parents have been charged. How does charging them differently affect the case strategy? Because the dad has the most serious charges.
Right. So I think he's charged with aggravated child abuse, which I think is going to be for using the pole or hitting the child and leaving the bruises. And I believe then both of them, it looks like, are charged with aggravated child endangerment, which again is an A felony, but that is essentially for a charge for a parent or a custodian failing to protect or not protecting your child, either from abuse or from a situation that would likely cause serious bodily injury or death to the child. So it looks like maybe that's what the mom is charged with. And I saw that there were 2 counts. So I would assume that has to be applied to 2 different kids, 2 of the 7 kids that they're talking about.
Could the mother's charges eventually be upgraded or even dropped based on how she cooperates?
Sure. Anything is possible. Once a case gets into court, the prosecutor has complete authority and discretion of how to handle a case like this or any case that they have for that matter. And so, yes, it could be if the mother cooperates, the charges could go away against her. It could also be that as these kids are all interviewed and given forensic interviews, they may make other accusations or allegations regarding other types of abuse or something. And so it is correct that the charges to the mother could certainly be increased, or they could add charges as the case goes through and ends up getting indicted by the grand jury.
And even though they are married and they couldn't be compelled to testify against one another, we see all the time that sometimes one of these parents may take a deal, they may try to flip on the other. Is that something that we could see in this case?
I think in every case, like you and I have talked before, anytime there's co-defendants in a case and it seems that there is one co-defendant that may be more culpable or their acts are worse than the others, there's always going to be discussions with the attorneys and the prosecutor of, one witness cooperating and testifying against another or testifying in exchange for some kind of leniency. So I would imagine whether that happens or not, I don't know, but I would certainly think that that's going to be something that both sides will be contemplating as the case goes on.
And there were 7 kids in that house at the time when police were there. I mean, even if the physical abuse was isolated to one child, can neglect of the others still result in prison time?
Potentially the neglect, but I think what is probably more likely is that through the DCS part of the investigation, that case will be in front of a different judge. It's called a dependency and neglect proceeding, and that is not about whether someone goes to prison or not, but that's about who gets custody of the kids. And so if it's in court and a family law judge finds out about these kinds of conditions, and that the other kids were subjected to certain things like this, then it could mean the end of their parental rights, or certainly the custody could be taken away from them for whatever period of time the court would deem appropriate. And usually what happens is the court takes custody away from them. Whether they terminate their parental rights is a different proceeding, but it would be something that they would have to do all kinds of things before they could go back in front of a judge to try to get custody of their kids back.
And of course, everyone is innocent until proven guilty. But I am just, when it comes to custody of these kids, just wondering, how could they get it? I mean, we are talking about some serious accusations here. Feces, smeared walls, no running water. How can a person try to get their kids back after something like this?
Well, it's certainly, there's going to have to be all kinds of conditions and hoops that the mother would have to jump through, or I guess the father, if the accusations are not correct about the child abuse that he's alleged to have committed. But there's parenting classes, anger management classes. There's all kinds of things that the family law court would put conditions on. And sometimes that takes years before that person could come back. And then ultimately there's going to be a guardian ad litem, which is an attorney who is there to advocate for the best interest of the child. That guardian ad litem will also make recommendations to the court based on their own investigation. And ultimately the judge would have to make a decision if they think it's in the best interest of the child to ever go back to the parents or not.
Right. And so at this point, I mean, we're talking about 7 kids. Anything is possible, but in a lot of these instances, the kids get separated from their siblings. Like, walk us through what happens when a child does get removed from the home. What happens to them now? Because they're truly the victims here.
Absolutely, and it's a sad thing, no matter where you live and however it works, because you're talking about Department of Children's Services in Tennessee, it's DCS, and that's an organization that's fraught with all kinds of problems as well. And there's not enough foster families for kids. Kids are in Tennessee specifically. I can speak to that there are often problems because there is nowhere to put these kids. The first thing that they will do is they would have gone into foster care. And whether that's with a temporary foster family or in some kind of a facility, they will try to hold them until they can find a better place. They're always going to try to find some family member to do a home check to see if there's someone that can take the kids. But then ultimately, they're going to be in the custody of the state, and where Department of Children's Service can find a proper place for those kids is a very difficult thing to do. And you're right. When you're talking about 7 kids, there's a very good chance that the kids are going to get split up, which is even more traumatizing when you and your siblings are going to get split apart, and you may not see your siblings after living in these kind of conditions to begin with.
How does the defense begin arguing this case? If you were their attorney, what would you do? Because there's physical evidence here as well. I mean, doctors found welts, bruises. I'm sure, medical records will become basically a roadmap for prosecutors.
Right. I think that's the first thing that's going to happen is you're going to start with the most serious charge in this, which is going to be the child abuse. So there should be the child should have been taken to the doctor. So there will be medical reports to review. There's going to be a bunch of photographs to review. I would assume that the child did a forensic interview, so they're going to review that interview to see what specific claims the child made. And then the state's going to have to look at those same factors, as well as, how how well that they believe that those witnesses would be able to testify in court, or kind of how good their forensic interviews are as far as what details they were allowed to give and explain to the situation that has happened to them. So, the allegations are shocking at the beginning, of course, anytime you hear something like this, but there's going to have to be a lot more evidence to this before, this is the kind of case that would end up going to a trial, or a kind of case that would get pled out.
So if you were their attorney, what would your argument be to combat this?
Well, I think the first thing is to see what the strength is in all of those things, right? The photographs, the interview, the child's interview, the medical reports. One of the things about child abuse is the way the statute reads. If you spank a child and the child is under the age of 8 and you leave a mark or a welt on the child, you could get charged with a Class A felony just like this. And so that's why it's so important that the prosecutors hold so much authority and discretion on how to handle these types of cases, because, a parent who spanks their child and leaves a mark on them, maybe, 15 to 60 years in prison is far too harsh for something like that. So even though technically under the law that may qualify, I think most people would probably agree that, well, I don't think that you should go to prison for that amount of time for spanking your child and leaving a mark. Now, certainly there may be more extreme examples of that where maybe that is justified, but because the stakes are so high, because the type of punishment is so severe, it really does put a lot of pressure on the prosecutor to try to come up with what should be a just and fair resolution.
So before I let you go, I mean, obviously a lot of these cases end in plea deals. Do we expect it to happen here?
Well, just because of the percentage of cases, we always expect cases are going to end in a plea deal. I think more than 99% of cases across the country are disposed of in some way other than a jury trial. And so if you just play those odds, then it seems that certainly this is the case that's going to end in a plea. And the other thing is, like we've talked about, these are such shocking accusations that you can imagine how a jury would see that, right? So jurors are just regular people like any of us that live in a community that get jury duty, and you show up to jury duty and you find out about someone locking a kid in a dog crate or beating a kid with a pole. As a defense attorney, those are things you have to be very, very careful about ever presenting to a jury, because a jury is certainly going to react emotionally about that. Another reason, I think, on the defense side, of course, you're always going to be trying to work out, the least, I guess, the least restrictive alternative you can come up with for your client. And in a situation like this, probably anything not to go to trial.
Well, this is a case that we will be following closely. Josh, thank you so much for coming on today.
Absolutely. Thank you. Have a good day.
The children have been removed from the home. Jason and Amber Hoffer are currently in custody at the Knox County Roger D. Wilson Detention Facility. For Law and Crime, I'm Kennedi Walker.